Hi, it's Mike DelSignore. I'm a Massachusetts OUI lawyer. In this video, I want to explain what happens and how you appeal the breath test refusal suspension. So this is a suspension you get when you refuse a breath test. You get an automatic suspension. You can appeal it. You have 15 days to appeal it. So I've done countless appeals on breath test refusal suspensions. I handle OUI cases all over Massachusetts. We go to courts from Worcester, Newburyport, Barnstable, Attleboro, Fall River, Brockton, Dedham, Stoughton, you name the court. I've been there and I've defended somebody charged with an OUI. And in many cases, I've done a breath test refusal appeal from that court. So the breath test refusal appeal, first of all, let's talk about how long is the suspension. Well, for your first offense, it's a 180-day suspension. If you're under 21, it's a 3-year suspension. If it's your second offense, it's also 3 years. If it's your third offense, you're looking at 5 years. And if you've had 3 prior convictions, it's a lifetime suspension for the refusal. Now, if you have a CDL license, a second refusal also is a lifetime loss on your CDL. A refusal on a CDL, first offense, is a 1-year suspension. So regardless of whether you're in your CDL vehicle. So CDL laws are very tough and stringent. So how do you appeal this suspension, and what's the process? So first, you have to go to the RMV or contact them. In this current climate of COVID-19, you can do it by mail or fax. You just have to have the contact information of a hearing officer. I know hearing officers, so my clients don't go to the RMV. We do it administratively. If you represent yourself, you're probably gonna have to go to the RMV. So you fill out a refusal packet, and in that packet it asks questions. Was there reasonable grounds to stop you? Did the officer have probable cause to arrest? Were you placed under arrest? And did you refuse a breath test? Now, I generally have my clients fill out this information by just denying everything. The RMV, in my experience, is never going to give you your license back on these issues. The burden is on the claimant to demonstrate they weren't under arrest, there wasn't reasonable grounds, or they didn't refuse. In most cases, those issues aren't there. The one exception is if you tried to take a breath test and you couldn't breathe into the machine. I've had cases where we presented documents showing that it wasn't your fault, but it was the fault of the machine. Now, often the RMV is going to deny this appeal too, but I think you have a better shot with that issue at the district court. So what happens is the RMV, in probably 99 out of 100 cases, is going to deny the appeal. I've filed countless appeals, and I've had 2 overturned by the RMV, and both were on the same issue, that the person wasn't placed under arrest. So if you weren't placed under arrest, you were given a citation. You can't be suspended for refusing a breath test, and the RMV will actually honor that. Otherwise, you're going to lose at the RMV, and you have to appeal to the district court within 30 days. When you appeal to the district court within 30 days, then we would argue the legal issues before the court. These appeals are difficult to win. A lot of refusal appeals are denied. I'll tell you about the issue I appeal it on. I haven't taken this issue up to the Massachusetts Supreme Court, but I may, because I think I'm right on this, and a lot of judges have rejected the argument. And here's the argument. To sustain a breath test refusal, the officer has to prepare a report of refusal under the pains and penalties of perjury. And that's what the law says, under the pains and penalties of perjury. I interpret this, and I think the logical interpretation is that means the form should be signed. They never sign it. There's a form, and it says, report under the pains and penalties of perjury, yes, yes. Then there's a disclaimer at the bottom saying that there might be errors in the form. So this form the registry uses, in my opinion, doesn't comply with the law, because the law says pains and penalties of perjury. When the law uses that language, my argument, and some judges have accepted this, is it has to be a signature, that it can't be a pre-printed form that doesn't appear anyone's ever looked at it. Recently, there were some issues where people were suspended for refusing breath tests when they shouldn't have been. There was some mistake. The RMV revealed that, and that issue is in front of Judge Brennan. So there is an issue with offices taking these forms and filling them out seriously, and the lack of a signature, I think, undermines the argument that this is done under the pains and penalties of perjury. So if the judge in the district court, so you can make that argument, make that legal argument, about the form, and then in most cases, most people just flat out refuse. So there might not be any other issue. If you tried to take the breath test, you can assert that as well. If it's denied, then the next level appeal. I usually don't appeal it beyond the district court. I have maybe 4 times where you can then appeal it to the Superior Court and then to the Supreme Court, which I haven't done yet. But that's the breath test refusal appeal. Like I said, most of these suspensions are going to get upheld. There is a way, though, to get your license back on a refusal prior to the suspension ending, and that's you got to go to trial and win the case. And that's generally how we get people their license back on refusals. We go to trial, we win the case. The judge will often reinstate the license. So if you refused a breath test, keep in mind the case is more difficult for the government to prove at trial. So when you refuse a breath test, they don't have a key piece of evidence. It's a very subjective case. So consider fighting the case. Make sure you have an attorney experienced in fighting OUI cases to discuss the pros and cons. Make sure that they're doing the little things. We go to the scene, we talk to all your witnesses, make sure we have all video evidence, because what makes the difference between a guilty and a not guilty may be just one piece of evidence. The whole point of these cases is to have a theory, to be able to show to the jury that what the officer saw wasn't an indicator of you being under the influence of alcohol, but it could have been you were tired. It could have been a lot of other things. It could have been you were nervous, that these field sobriety tests aren't accurate and reliable. In other words, just because you couldn't walk out 9 steps, turn around, come 9 steps back, just as the officer says, doesn't mean you were under the influence of alcohol. In many cases, the officers don't explain the test correctly. They explain it quickly. You can't really hear on the side of the road. You don't know the implications. The officer will say, walk heel to toe. Well, what does that mean? Does that mean you got to bang your feet together? Well, that's how they're going to score it. If you don't literally bang your feet together, they're going to say you failed. Where heel to toe, most people think that's the feet fairly close together. Stepped off the line. Did you know that if you didn't walk exactly on that line, they were going to say you were under the influence of alcohol? A lot of times they'll say you started too soon. They don't tell you, hey, if you start soon, before I say, if you try to practice this like normal people would do, I'm going to assume you're under the influence of alcohol. So they don't tell you that. If you knew how you were going to be scored on these exercises, you would do differently, but you don't. You don't know how it's scored. You think a lot of these officers are kind of friendly, like, okay, I'm just going to give you some tests. And then they were grading you on minutia, and you didn't know that. If you knew that, you would have done better on the test. And sometimes I talk about an experience in my life when I was, I'll explain this to a jury, and I think it helps with the connection. When I was in high school, started 9th grade, my dad, plumber, my mom also worked at a jewelry store. So I didn't come from a background where my parents were always telling me about college and grade point averages. And I went out with a group of sort of the smarter kids. I was on a date at the time. And I remember being at the restaurant and they're talking about grade point average, class rank. I remember thinking to myself, someone is keeping track of this stuff. I didn't know that we were being great. I didn't know that there was a ranking system. And then I learned about how class rank worked, where if you were in an honors class, you get 1 level on your GPA. And I knew the scoring system. It went off. And all of a sudden, I was like a better student. And it's that knowing how you're being scored, how you're being judged is critical. So these officers, they're saying you failed a test. You really didn't understand. You didn't know that the officer was going to look for every little thing to say you're drunk. So I got a lot of different stories. The key to being a good trial lawyer is to connect with the jury, to try to tell your story in the most compelling way possible. I spend a lot of time and money doing the best I can with that. I have coaches that I work with that are non-lawyers, storytellers. We haven't been doing as many trials because of the virus. Just maybe last week, I did what they call a story slam. It was kind of like something where I can get out and sort of simulate a trial. So I love doing this. I love standing up in front of a jury to tell your story, to help you in your life, to make a difference, to give you that fresh start that you want. So if you refuse a breath test, they don't have the biggest piece of evidence. Hopefully you didn't. if there's an admission, we can sometimes deal with that. I'll talk about whether you want to testify or how we deal with the key evidence that the government has. So consider fighting the case, going to trial. There's the breath test refusal process. If you have questions about that, feel free to contact me. My name is Michael DelSignore. I'm here to help. Never too early, too late to call. I love talking about OUI cases and helping people get their life back together. So call anytime, 781-686-5924. And I'm here to help whenever you need it. You can call, text at that number.